Hey guys, in this video, we're going to talk about something that might surprise a whole lot of people. This involves foreigners who were denied a visa. They now have the ability to sue the federal government for denying them the visa. We're going to talk about it in this one because this is super interesting and potentially an open door to, who knows, maybe other lawsuits. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide. Friends, reach out to us at McBean Law if you need further assistance with your immigration case. Before you go today, if you enjoyed the content that I share with you each week, subscribe to my channel, hit the notification bell, and you'll be the first to get notice of these videos each week. Now let's talk about this. Remember 2018 when Donald Trump was in the White House? This is before COVID, of course. He created various travel bans. One of those bans, friends, was targeted to certain countries that the US or President Trump deemed to be a threat to the US government. In the ban, however, there was a process that would allow some visa applicants from those countries to be able to apply for a waiver and show that they're eligible for the visa to come to America. A group of individuals have come together in a class action lawsuit against the federal government, and these are foreigners, guys. These are people who are not in the United States currently. They haven't even applied for a visa since being banned under the Trump administration, but they've come together, filed a lawsuit, and a judge has recently decided the issue that yes, they are able to do this. They can form this class action lawsuit, so to speak, and move forward with the case. So let's talk about the details. And this is from Bloomberg Law. Trump travel ban suit brought by visa applicants to move ahead. The visa applicants in this case were alleging that they were unlawfully denied entry to the U.S. under former President Trump's travel ban. The court has said that they can sue federal officials as a class. And this is the latest development in this case. The foreigners are arguing, they have argued since 2018, the Department of Homeland Security and other federal agency officials improperly implemented Trump's restrictions on travel and immigration by ignoring a provision that was meant to grant waivers to some applicants. The group argues the denial of waivers caused them or their family members dislocation. And this is happening in California, the Northern District of California. It's made up of a group of people from Iran, Libya, North Korea, Somalia, Syria, Venezuela, and Yemen. Those countries, friends, as you guys know, are hot button countries to the US government. Those were the first countries that were targeted during the Trump years under the immigration policies, okay, to ban folks from coming into the United States. The class of individuals consists of people who didn't obtain a waiver. They have not subsequently obtained a waiver. They haven't reapplied for a visa since the proclamation was revoked by the Biden administration. So you might be saying, well, why don't they just reapply? Why don't they just try again? Biden is obviously very friendly and welcoming of immigrants from every country. There's no more much discrimination in our system under the Trump years. Why don't they just reapply? Well, perhaps it's because they have something more substantial to gain from this particular lawsuit. Who knows? I don't know. But in any event, what the judge is allowing them to move forward with this process. The Biden administration, of course, is arguing against this. Some of you might be surprised by that. They are arguing about this because they're concerned about the potential floodgates being opened if foreigners are able to sue the federal government for denying them a visa. And we're going to get into a little bit of the legality of that momentarily, but the government's position is that the government had told the court that it would provide meaningful relief to the approximately 41,000 visa applicants who were denied a visa under the travel ban. The government had earlier proposed it would notify these 41,000 plus individuals directly and advise them that if they wish to reapply for a non-immigrant visa, they may do so without paying a second fee. This all went up in smoke, however, when government lawyers later said they didn't agree to specific relief. Very hard for the government to agree to providing relief for 41,000 foreigners. So the judge rejected the government's argument that certifying the class, it would improperly involve the court in the government's visa decision-making process. What they're talking about here is a doctrine of consular non-reviewability. That particular doctrine stops foreigners from suing the government and forcing the government to intervene with a decision that a consular officer made in Japan or wherever the U.S. Embassy is across the globe, in Manila, Kingston, Jamaica, wherever it is, right, London, it stops the federal government from digging in and reviewing that officer's decision making. They have broad discretion to deny or approve visa applicants. And so this doctrine of consular non-reviewability is really significant in our laws. What the government was arguing here is that if this goes forward, it would run counter to this long-standing doctrine that we have in our system here. The plaintiffs are saying it's completely irrelevant. This has nothing to do with that doctrine of consular non-reviewability. The government is way out of line for even arguing that. The judge has again allowed this particular class to be formed so that this class action lawsuit can move forward. Trump's travel ban was upheld by the Supreme Court in 2018, the ruling Trump v. Hawaii, with justices split in 5-4 along ideological lines. Muslim advocates and others represent the proposed class. We're going to keep an eye on this. This is super interesting. It's interesting from the standpoint that this has implications down the road for others to form class action lawsuits against the U.S. government, alleging that the government did the wrong thing under various bans and we should not have been denied our visa. What we're seeing here is different from the ordinary person goes to the U.S. Embassy for a visitor visa interview and they're denied. Can they now get together, form a class, sue the government for denying them? No, they cannot do that. Here, they're arguing that the government, through the ban that Trump had set up, the government created a small pathway for some individuals to apply for a waiver of that ban so that they could come in. These individuals are saying, well, that wasn't handled properly. It wasn't set up right. And because of that reason, we were denied this opportunity. Anyway, guys, let me know your thoughts below on this issue. What do you think about it? Share this with other people. Don't forget to subscribe to this channel. Also, subscribe to our firm's newsletter so that you'll get more free tips from us. Go to McBeanlaw.com/subscribe and subscribe to our newsletter. Thanks for being with me, and I will see you in the next one. Bye-bye.